This is something we almost never see in American legal history, and I need you to stay with me here because what is unfolding right now is not speculation, not rumor, and not political spin. A former First Lady of the United States is on the verge of being forced to testify under oath about her marriage, her living arrangements, her tax filings, her financial records, and her connections to Jeffrey Epstein. This is not happening behind closed doors. It is happening in federal court under established legal procedure, with consequences that cannot be undone. What makes this moment truly unprecedented is not the subject matter, it is the cause. This crisis was not triggered by an investigative expose, not by a whistleblower, and not by a criminal indictment. It was triggered by a single catastrophic legal decision made by Melania Trump and her own legal team. There was no ambush, there was no conspiracy, and there was no judicial trickery. This was a trap of her own making, and once it was sprung, there was no way out. While most Americans are focused on political headlines and daily noise, a far more dangerous process is quietly moving forward. A process that does not care about status, power, or proximity to the presidency. A process governed by sworn testimony, documentary evidence, and penalties for perjury. And once this process begins, it does not stop simply because the person involved is wealthy, famous, or politically connected. This is not a scandal story. It is not gossip. It is a step-by-step breakdown of how a routine legal threat turned into a full-scale legal catastrophe. How a billion-dollar defamation warning backfired, how an attempt to silence a journalist triggered mandatory discovery, and how one procedural decision placed the private life of a former First Lady under the harshest light the legal system can impose. This is not about politics anymore. This is about accountability, and the moment accountability enters the courtroom, control disappears. To understand why this situation is so dangerous, you have to strip away the names, the politics, and the headlines and focus on the mechanics. Contrary to popular belief, Melania Trump is not being forced toward testimony because of what a journalist wrote. She is not facing this moment because of new allegations or secret investigations. She is facing it because of a legal strategy choice, a choice that turned a manageable defamation dispute into a procedural nightmare. Lawyers have a term for this, an unforced error. No judge ordered it, no opposing attorney demanded it, and no statute required it. Melania Trump and her legal team voluntarily took a case already in progress and moved it into a jurisdiction where the rules are far less forgiving. And once they did, they triggered legal consequences that cannot be paused, negotiated away, or spun in the press. At its core, this case is not about reputation, it is about jurisdiction. It is not about headlines, it is about procedure. And in the American legal system, procedure is often more powerful than substance. You can win on facts and still lose on process. You can have sympathetic judges and still be forced to answer questions you never wanted asked. That is exactly what has happened here. Melania Trump did not lose control of this case because she lacks resources. She lost control because federal courts operate on rigid rules that do not bend to personal preference. Once you invoke those rules, you submit to them completely. There is no partial participation, there is no selective cooperation, there is only compliance or consequence. This is why this moment matters. What we are watching is not a celebrity scandal spiraling out of control. We are watching the legal system do exactly what it is designed to do when someone tries to weaponize it. It removes discretion, it removes leverage, it removes intimidation, and it replaces all of it with sworn testimony, document production, and permanent public record. To see how fast this spiraled, we need to go back to where it actually began, not in a courtroom but in a letter. In October, journalist Michael Wolff received a legal demand that immediately signaled escalation. It was not a request for clarification, it was not a negotiation, it was a threat. A threat of a $1 billion defamation lawsuit. Billion with a B. The message was simple: retract what you wrote about Melania Trump's connections to Jeffrey Epstein, apologize publicly, or face financial destruction in court. This tactic was familiar. For years this has been the Trump legal playbook: overwhelm critics with the threat of ruin and make the cost of speaking higher than the cost of silence. In most cases it works. Journalists retract, publishers soften language, stories disappear. The threat alone is enough. But this time the calculation failed. Michael Wolff did not apologize. He did not go silent. He did not wait to be sued. He went on offense. He filed first, and in doing so he flipped the entire power dynamic. The threat became a lawsuit. The private intimidation campaign became a public legal record. And once that happened, the Trump legal team lost the one thing their strategy depends on above all else: control. Wolff's filing did not hedge, it did not retreat. It addressed every allegedly defamatory statement one by one, explaining why each was either demonstrably true, protected opinion, or stripped of context. Then came the most consequential move. Wolff framed the threat itself as a strategic lawsuit against public participation, a SLAPP suit. A case designed not to win but to intimidate critics into silence. That framing changed everything, because once a court is asked to examine whether litigation is being used as a weapon against speech, the intimidation itself becomes relevant. This is where the Trump legal playbook historically collapses. It works in the shadows. Wolff dragged it into daylight. At that point, Melania Trump's legal team still had options. The case was active in New York State Court, where procedures are familiar and discovery is more limited. But instead of staying put, her lawyers made the decision that changed everything. They attempted to remove the case to federal court. On paper, it looks strategic. Federal courts have different rules, and defendants often believe federal judges are more restrained. The case was assigned to a Trump-appointed federal judge. From the outside, it looked like everything was falling into place. But federal court is not simply a different venue, it is a different system. To move a case from state court to federal court, the party requesting removal must establish a valid basis for federal jurisdiction. In this case, that meant diversity jurisdiction. The rule is strict. The parties must be citizens of different states. Michael Wolff's residency was never disputed. He is a New York resident, which meant the entire strategy hinged on one thing. Melania Trump had to prove that she was not a resident of New York. The moment her lawyers made that claim, the trap snapped shut because, under federal law, when jurisdiction is disputed, the opposing party has an absolute right to challenge it through discovery. That single procedural move transformed a defamation dispute into a full-scale examination of Melania Trump's life, not because of what she was accused of, but because of where she claims to live. Once jurisdictional discovery begins, control is gone. This is the moment where the case stops being theoretical and becomes operational. Once Melania Trump's legal team invoked federal jurisdiction, they did not simply move the fight to a different courtroom. They triggered a mandatory legal mechanism known as jurisdictional discovery. And unlike ordinary discovery, this process is not optional. It is not discretionary, and it is not something a judge can simply limit away for convenience or embarrassment. Jurisdictional discovery exists for one reason only. Before a federal court can proceed, it must confirm that it has the legal authority to hear the case. And when one party challenges that authority in good faith, the court is required to allow discovery sufficient to resolve the question, not argument alone, not affidavit alone, but discovery. That means sworn testimony, written interrogatories, subpoenas for documents, and penalties for false statements. At the center of this entire process is a deceptively simple question: where does Melania Trump actually live? But answering that question requires peeling back nearly every layer of a person's private life. Where does she sleep most nights? How many days per year does she spend at each residence? What address appears on her tax filings? What state does she claim for residency benefits? What properties does she control, and how are they actually used? These questions are not invasive because of who she is. They are legally required because of the claim her lawyers made. And every answer must be given under oath. This is not a media interview. It is not a public relations appearance. It is sworn testimony. Every statement carries the risk of perjury if it is false or misleading. And jurisdictional discovery does not stop with testimony. It extends to documents. Tax returns, property records, financial disclosures, travel records. Anything that could establish or contradict a claim of residency becomes fair game. The scope may be narrow in theory, but in practice it is devastating because once documents are produced, they exist independently of explanation or spin. What makes this stage so dangerous is that jurisdictional discovery is binary. Either the residency claim holds up under scrutiny or it does not. There is no partial victory. If the court determines that Melania Trump is in fact a New York resident, the case does not quietly slip back to state court as if nothing happened. The discovery already conducted remains part of the record. The answers already given cannot be taken back. This is the irreversible point. Once discovery begins, control is gone. The narrative no longer belongs to lawyers or publicists. It belongs to sworn testimony and documentary evidence. From this moment forward, every attempt to avoid scrutiny only deepens it. If all of this still feels abstract, this is where it becomes concrete because residency is not determined by a single statement. It is established through patterns of life. And one of the clearest windows into those patterns involves Melania Trump's son, Barron. Barron Trump is currently a student at New York University in Manhattan. That fact alone is not controversial, but what matters is how residency was represented in the admissions and enrollment process. Universities do not treat residency casually. Tuition rates, eligibility, and financial considerations often depend on whether a student is considered in-state or out of state. The difference can be substantial. If Barron was listed as a New York resident for tuition or enrollment purposes, that creates a direct contradiction with any claim that Melania Trump is a Florida resident. If she claimed Florida residency for tax advantages or federal jurisdiction while simultaneously representing New York residency for her son, that inconsistency becomes a serious legal issue, not a political issue, a legal one. This is why jurisdictional discovery is so unforgiving. It connects systems that are normally separate. Tax filings do not exist in isolation. School records do not exist in isolation. Property exemptions do not exist in isolation. When they point in different directions, courts take notice. And this issue does not stop with paperwork, it extends to daily life. For years, reporting has consistently described Melania Trump spending the vast majority of her time in New York City, maintaining a residence on Fifth Avenue, and structuring her life around her son's education. In another context, that reporting might be dismissed as lifestyle coverage. Here, it becomes evidentiary because now Melania Trump must reconcile public reporting, documentary records, and sworn testimony into a single coherent narrative of residency. Any discrepancy becomes discoverable, any inconsistency becomes relevant, and any falsehood becomes dangerous. At this point, many observers assume there is still an escape hatch. They look at the judge on the bench and assume the outcome is predetermined, a Trump-appointed judge, a favorable record, a history of rulings aligned with Trump interests. Surely this is where the system bends. That assumption is wrong. Jurisdiction is not a matter of preference. It is not ideology. It is not sympathy. Federal courts do not get to choose cases based on who the parties are. They must first establish that they have the legal authority to hear the case. And when that authority is challenged in good faith, discovery must be allowed. This is not discretionary. A judge cannot simply decide that discovery would be inconvenient or embarrassing and shut it down. Doing so would create an immediate appellate issue. Federal procedure exists precisely to prevent judges from picking winners before jurisdiction is established. Once Michael Wolff's attorneys articulated a legitimate basis to question Melania Trump's residency claim, the process became automatic. The court is required to permit discovery sufficient to resolve that question. That obligation exists regardless of who appointed the judge and regardless of the political pressure. This is why the phrase, Trump judge, loses its power here. Even a sympathetic judge cannot protect a party from the consequences of invoking federal jurisdiction. The law does not allow it, the rules do not permit it, and the record must reflect compliance. All of this exposure is occurring in service of a defamation case that is, at best, weak. The statements identified as defamatory collapse under scrutiny. They are either contextual reporting, protected opinion, or historical fact. Courts routinely dismiss defamation claims built on such foundations. This is the cruel irony of the situation. Melania Trump is enduring invasive discovery, sworn testimony, and the exposure of deeply personal records to pursue a case she is unlikely to win. She is paying the highest possible legal price before the merits are even reached. Every document produced, every answer given, and every inconsistency uncovered exists independently of whether the defamation claim survives. Even if the case is ultimately dismissed, the damage from discovery cannot be undone. This is maximum exposure for minimum return. At this stage, the question is no longer whether this situation is damaging. The question is whether there is any viable way out. And the honest answer is that every remaining option carries consequences that Melania Trump's legal team can no longer control. One possibility is to voluntarily withdraw the removal and send the case back to New York State Court. But that path requires an admission that the federal strategy was a mistake. It confirms that the decision to invoke federal jurisdiction was unsound. And even then, it does not erase what has already happened. Discovery conducted in federal court does not vanish simply because a case changes venues. Statements made under oath remain statements made under oath. Documents produced remain documents produced. The toothpaste does not go back into the tube. Another option is settlement, but settlement requires leverage, and leverage requires fear. Michael Wolff has demonstrated none. He did not retreat when faced with a billion-dollar threat. He did not negotiate silence. He invited scrutiny, and at this point discovery serves his interests. It reinforces the very claim that the lawsuit was intended to intimidate rather than to resolve a legitimate grievance. For Wolff, sunlight is not a risk, it is an asset. A third option is to attempt to limit the scope of discovery. But jurisdictional discovery is not negotiable in the way ordinary discovery can be. As long as residency is genuinely disputed, the court must allow inquiry sufficient to resolve it. Narrowing that inquiry too aggressively creates appellate risk. Judges know this, lawyers know this, and opposing counsel knows it too. Attempts to constrain the process often invite expansion, not limitation. That leaves only one likely outcome. The case proceeds exactly as federal procedure requires. Depositions occur, documents are produced, answers are locked into the public record, and every inconsistency becomes a potential point of further inquiry rather than a dead end. For Donald Trump, this is a nightmare scenario. His entire career has been built on controlling information, shaping narratives, and using legal pressure to prevent uncomfortable facts from surfacing. This process does the opposite. It compels disclosure, it removes timing control, and it creates a permanent evidentiary trail that does not respond to spin or intimidation. From this point forward, the case is no longer about what Melania Trump wants to say, it is about what she is legally required to answer. That distinction matters. Once sworn testimony begins, the audience is no longer the public, it is the record, and the record does not forget. It would be a mistake to view this as a personal downfall or a celebrity legal drama. What is unfolding here is larger than any individual. It is a rare moment where a system designed to protect free expression is being tested by someone accustomed to avoiding its consequences. For decades, powerful figures have relied on a simple formula: threaten litigation, inflate damages, exhaust the opposition, and silence criticism, all without ever having to prove anything in court. That strategy works because most people cannot afford the risk. Most people retreat. Most people comply. This case broke that pattern. Michael Wolff refused to retreat. He did not ask for permission to speak. He did not negotiate silence. He forced the dispute into a courtroom where threats lose their power and facts gain weight. And when that happened, the legal system did what it is supposed to do. It removed leverage and replaced it with rules. Those rules apply to everyone. They do not care about wealth, they do not care about proximity to power, and they do not care how uncomfortable the truth may be. When someone invokes the legal system to intimidate, they also accept the risk that the system will turn its attention back on them. That is why this moment matters beyond the Trump family. It sends a signal to journalists, critics, and ordinary citizens who have been threatened into silence. The law is not just a weapon for the powerful, it is also a check on abuse. But it only works when someone is willing to test it. Accountability rarely arrives with sirens or indictments. More often, it arrives quietly through procedure, through discovery, and through sworn testimony. It arrives when questions must be answered instead of avoided. And once it arrives, it does not announce itself as justice, it simply operates. That is what we are watching now, not spectacle, not revenge, but accountability in motion. What happens next is no longer theoretical. The discovery process is underway, the questions have been authorized, the documents will be demanded, and depositions are coming. When Melania Trump sits down under oath, she will not be speaking to the public, she will be speaking to the record. Every answer will be fixed in place. Every document will exist independently of explanation or spin. And once those materials enter the record, they become available for journalists, investigators, and the public to examine. This is how quiet legal disputes become historical reference points, not because of what was alleged, but because of what was proven, contradicted, or left unexplained. This is the moment Donald Trump has spent his career trying to avoid, a process that cannot be intimidated, a process that does not negotiate with power, and a process that requires truth under penalty of law. And it is unfolding not because of a criminal indictment, but because of a failed attempt to silence criticism. 3 things are now clear. First, the decision to move this case to federal court was a catastrophic error with irreversible consequences. Second, the defamation claims at the heart of the dispute are weak compared to the exposure now created. And third, once discovery begins, control is permanently lost. This story is far from finished. In fact, it is only entering its most consequential phase. When testimony begins, every word will matter, every inconsistency will matter, and every attempt to obscure the truth will carry risk. Make sure you are subscribed and notifications are turned on, because when the record starts filling in, we will be here to break it down line by line.